So good afternoon, everyone. Well, it's afternoon here in Lagos and wherever you're joining us from. I just want to welcome you very, very specially to the October edition of the CIFA webinar, the Christian Financial Accountability Association webinar. I want to welcome all the men of God and all senior ministers, church leaders, who may be joining us this afternoon. We welcome you very, very specially. At this webinar today, we will be looking at the issue of trustees board, how to put it together, who qualifies to be on the board, and other ancillary issues, perhaps like tenureship and other things like that. And also we're going to be looking at the big masquerade, which is usually the issue of remuneration for pastors, especially the senior pastors and in the ministry, and the tax implications. And we have erudite scholars and men that are trusted with knowledge to guide us through this discussion today. I'm going to say a prayer, and then I'm going to introduce our compare, and we're going to start off from there. Please let's have a word of prayer. Our Heavenly Father, we thank you for the opportunity to come together at this time for this webinar. We thank you for your sons and daughters from far and near who are joining us on this call today. Lord, this is about your kingdom. This is about your agenda. So we ask, Father, that you guide us, that you lead us as we deliberate today. Lord, let everything that will be said and done bring glory to your name and lead to the furtherance of your kingdom here on earth, and especially the church that you have set up in our nation, Nigeria. Make this webinar a strong contribution into your church in our nation at this time. We thank you for your presence, and we release ourselves to you, Holy Spirit, that you speak through us and guide us in Jesus' precious name. Amen. All right, so our compare for today will speak to us about each of our speakers as she enables them, and then the webinar will continue to guide us and to guide us through the deliberation. Even when it comes to the time of Q&A, she will coordinate all the things that we'll do through that. Sale is she's a broadcaster. She's a professional compare. She's also a child of God. I welcome you to CIFA October webinar. Thank you for joining us. And at this point, I'm going to hand over the baton to you, and we trust God to guide you as you guide us through. God bless you all. Please take over.
Thank you so much, Pastor Godman. And it's such an honor to be here amongst great men of God, and I'm truly honored to be here. Thank you so much for the honor to host this and compare this event. So without wasting much time, I just want to quickly say that in case if anyone has any technical difficulties, just avail yourself with the chat box. Just chat any difficulties that you might be having, so the admin will be able to sort you out in case you have any technical difficulties. So at this point, I'll introduce our first speaker, Dayo Adebayo. He is the managing partner at Adebayo & Adebayo, a corporate and commercial law firm that is the pioneering church law in Nigeria. It's a corporate and commercial law firm that is a pioneering church law in Nigeria. He is a barrister and solicitor of the Supreme Court of Nigeria, with an LLB honorables at Obafemi Awolowo University, Ile-Ife, Oyo State, and LLM distinctions, University of Cumbria, United Kingdom. He is a member International Bar Association, a member Nigerian Bar Association, a board member of many corporate organizations, including non-for-profit organizations. He is married to BC Adebayo, a co-partner at the law firm, and together they have 3 lovely adults and a blooming teenager called the Fantastic Four. So let's welcome Mr. Dayo Adebayo as he takes on the conversations further. Thank you so much for joining us, Mr. Dayo Adebayo.
Yeah, thank you so much. It's my pleasure being here, and I thank the organizers of this webinar. I mean, there cannot be a better time than this to organize a webinar on a topic like this. Well, Reverend Sam and the entire board, Pastor Godwin, I thank you for giving me this opportunity. I'm going to share today on what I've titled the legal status, duties and obligations of incorporated trustees in Nigeria. I'd like to start that by saying the Constitution of the Federal Republic of Nigeria guarantees what we call freedom of association. That is to say, any two or more persons can come together to form an association, and that is guaranteed under Section 40 of the 1999 Constitution of the Federal Republic of Nigeria as amended. However, there are limitations to such association. Such associations are not recognized by law, and there are some things that you cannot do. You cannot use your corporate name to transact any business whatsoever. Then you do not enjoy what we call corporate protection. And I'm going to explain that in the course of this presentation. So, but if you want to enjoy the benefits of being a corporate body, then you have to approach the Corporate Affairs Commission to be registered as an association. If not, the law will still recognize you as persons just coming together. And if anything happens, the law will hold you individually responsible for your acts and not corporately responsible. So if you intend to register as an association, or either as a church or a Christian faith-based organization, you have to approach the Corporate Affairs Commission. And the law on incorporated trustee is regulated by the Corporate Affairs Commission. And CAMA, that is a law, is unique in the sense that before CAMA came in 1990, churches and faith-based organizations were registered under what we call the Land Perpetual Subsection Act. So they were not registered by the company's law. But when CAMA came in 1990, it merged the Land Perpetual Subsection Act with the company's law. And so now we have what we call the Companies and Allied Matters Act. So the allied matters in this instance is the incorporated trustees, which regulates, which is the body that controls Christian faith-based organizations, churches, clubs, societies, NGOs, and the rest of them. So someone will ask me, who is a trustee? A trustee, like a friend will say, I have a friend who will say a trustee is a trusted person. Basically, a trustee is that person who holds property or rights on behalf of others. So in broadest sense, a trustee is that person who aggregates the rights of others in property and in other relevant rights for the benefit of the society. So he does not use the property for himself or the rights for himself, but he used those rights and the property for the benefits of the society. Basically, a trustee is a steward, is a person in position of trust. So if you want to register, so 2 or more people will have to approach the Corporate Affairs Commission, and they will indicate their interest to register. They will state their values, which will be enshrined in the Constitution, because the Corporate Affairs Commission will say, oh, let's see your Constitution. And if I'm going to mention the things you need to have later, but if you are approved by the Corporate Affairs Commission as a body worthy for registration, they will register you, the Corporate Affairs Commission will register you, and will give you a certificate of incorporation. Now, who are the people eligible to register. Because of my time, let me skip this. Okay, what do you need for eligibility? You need the name of the proposed corporate body. Your name will be checked for availability so that your name will not conflict with other associations or churches or Christian faith-based organizations that have similar names. If your name is approved, then the next thing they will check is the aims and objects of the association. Are they lawful? If you scale that hurdle, then the CAMA will require for the names, addresses, and occupations of the trustees and secretary of the association. The law is interested in who your trustees are. You can't just make anyone your trustee. I'm going to explain the qualifications for trustees later. But suffice to say at this point that the law is very interested in who your trustees are. And I will go to explain reasons why later. Now let's look at qualifications for trustees. Who can be appointed trustees? Well, the CAMA, that is the Corporate and Affairs Matters Act, does not specify those that can be appointed as trustees, but it lists qualifications for trustees. So that is to say, you can only be qualified, if you are if you pass, these four categorization. Number one, you are not an infant. Before now, an infant used to be anyone under the age of 21. Because we have the Infant Protection Act. The Infant Protection Act makes 21 years, the age of maturity. And we have the case of Labake and Labinjo, which says that anyone under the age of 21 cannot enter into a legal contract. But now, we now have what we call the Child Rights Act. The Child Rights Act makes the age of 18, the age of majority. So it's safe to conclude that an infant is anybody below the age of 18. So if you have anybody above 18, can qualify to be a trustee. Then that person should not be an undischarged bankrupt. A bankrupt person is that person who cannot, meet his financial obligations, is owing creditors. And what happens is when you are bankrupt, you go to court with a petition and you tell the court, you know what, I can't fulfill my obligations, and the court will declare you a bankrupt. But if you are discharged, because you can be discharged as a bankrupt by operation of law and by effusion of time, because in so many jurisdictions they have different times. In some places, after 3 years, 1 day, then you are free. Your status will elapse as a bankrupt. So, but again, you can also go to court if you are able to meet up your obligations thereafter, or for whatever reasons the court declares you by another of the courts discharged, then you can qualify. But as long as you're on discharged bankrupt, you can't qualify to be a member of the Board of Trustees. Then anyone of unsound mind who has been so found by the courts. So this is, discretionary. And it's only the courts that can adjourn in this situation whether one is of unsound mind. Because again, this provision subsists, even during the currency of your trusteeship. What I'm saying in essence is, even while you are a trustee, some people might go to court and say, oh, this man is of unsound mind, I want to remove him. It's only the court of law that can determine that, whether it's of unsound mind, because it will be required to undergo some tests, which will be ordered by court. So if you've been found by a court of law to be of unsound mind, you can't be a trustee. Then persons convicted of offense involving fraud or dishonesty, within 5 years before your appointment, then you cannot qualify to be a trustee. Now let's look at the status that registration will confer on you. If you go to CAC and you are registered, what status do you have, as incorporated trustees? The trustees become, what we call a body corporate. They become legal personalities. And what it means is that the trustees are not looked as individuals anymore, but they are looked in the eyes of the law as an entity, a corporate person. So they now enjoy what we call the veil of incorporation. That is, that registration bonds them together and gives them a cover. Then the number two, it means that the trustees have perpetual succession. That is, they can live forever till Jesus Christ comes, if they wish. If the objects of the associations have not been concluded or fulfilled, the trustees can live in perpetuity. That means perpetual succession. Okay? Then the trustees are the only one that can sue on behalf of the organization and be sued on behalf of the organization. There's a case, Ajayi versus Registered Trustees of Onomimo, Kiriwum, and Seraphim. In this case, the trustees board had been comatose for about 10 years, and a lot of them had either resigned or died. So some members of the congregation went to sell, a parcel of land that belongs to the church, and some other members rose up and took them to court that they have no power to sell. And when they got to court, the ones that sold challenged the rights of those that brought them to court. Said, look, you have no local standing. That is, you have no legal standing to bring us to court because you are not trustees. And at the end of the day, the court found for them and said, look, it's only the trustees that can sue on behalf of the church or a Christian faith organization or anybody that enjoys that status. Okay, so the trustees also hold and acquire, property on behalf of the church or the Christian faith-based organization. So they are the ones, who will hold the property and who will account for the property and who can transfer the property. So the trustees are also the ones that can enter into a binding legal contract. So no individual can enter into a contract except the trustees. Now, what is corporate governance? I'm just going to explain briefly, and I'm going to merge the two of them together, how they work hand in hand. Corporate governance, in its simplest form, is a system of rules, practices, and processes that are used by a corporation to direct its actions. So it consists of the 4 P's. So we have the 4 P's of corporate governance. We have the people there, we have the purpose, we have the process, then we have the performance. Now, like I said, for incorporated trustees, the association of 2 or more persons is in existence, before they go to Corporate Affairs Commission for registration. So it's all about the people, So the focus and the benefit for their trusteeship is the people. And when we talk about the people here, we are talking about the members of that association. Now we go to purpose. Every association, we have the aims and objects. I said before you can be registered, you have to show your aims and your objects, which have to be legal. So now, everything the trustees will do have to be within the purpose that they set out for themselves before registration or during registration. So the eyes of the trustees should be always on the purpose for which the organization is formed. If they deviate from the purpose, then they will breach the trust that has been reposed in them. Then corporate governance also talks about the process churches are organizations, and organization is all about processes. The processes should be clear to everybody. The organogram of the church should be clear. The layers of corporate governance should be clear. The risk management procedures should be clear to everybody. I'm going to talk a little about that later. Then it's also about performance. Again, you set out to achieve a purpose. You set out to achieve a goal. So the incorporated trustees must at all times make sure that they are working or moving towards the achievement of that goal. They should keep their eyes always on that goal, because again, they will be called to render account. So you do not dissipate the property of the organization. You do not run the organization bankrupt. But again, you have to use your skill to make sure that the organization achieve its set aims and objectives. And now, what are the principles of corporate governance? Honesty, transparency. Again, incorporated trustees, they should be like the proverbial Caesar's wife. They should be above board in their dealings. They should be honest. They should be transparent. I mean, you should be able to open your books, at any time for members to see, and you should also be able to be accountable to your people. You get back to them and say, oh, at the beginning of the year, you entrusted us with this amount of money, and this is how we expended this amount of money. These are the things we did. So that's accountability. So, okay, incorporated trustees also have that duty to be responsible. Then they have to be independent. I'm going to talk about the corporate governance structure in a bit, but it has to be separate from the management. And they have to take decisions based on their conviction, their exposure, their experience, and their skills. They don't have to dance to the tune of the senior pastor. They support the senior pastor. But again, when the truth needs to be told about running the organization, because they are the ones who will be held accountable at the end of the day. So it has to be independent, and senior pastors, as much as possible, or heads of church faith-based organizations, should try to make them independent. You are better off having a board that is totally independent. Then they have to be fair in their dealings, and they have to ensure the principles of social responsibility. You know that the whole essence of being an NGO, because you are registered along with NGO, is for you to be able to carry out some corporate social responsibility. So you must make sure that in your books, I tell people, because I do some trainings on this in this regard, and I said, look, if you're an NGO, church faith-based organization, even if you're a church, your accounts should easily show the type of organization you run. If you are running an organization and 80% of your expenditure is on payroll, salaries, and all this stuff, then something is wrong. The bulk of your expenditure should be on this item, social responsibility. So that should be the focus. Now let's look at the structure. Now the law provides, that's CAMA, provides for the board of trustees, which is at the apex. And it also provides for the council. Although the council is optional, so the board of trustees is not optional, you have to have a board. The council is optional. And those are the two, under CAMA 2020, those are the two layers of corporate governance that are provided. But the council is supposed to perform what we call administrative and management functions under section 836. However, there's a twist. The council under CAMA expects members of the Board of Trustees to be part of it, which I think, in my opinion, is a breach of, corporate governance, which I just discussed about. So what I will advise churches to do, or Christian faith-based organization, is to have the Board of Trustees as an independent board. Then instead of having your council, which is optional, you have a management committee which will perform administrative and management function. And you can have one or two people, from the board attending your management meeting if it's convenient for them. Then I also advise there's a pastorate, because it's a church. Then the General Assembly is the totality of the people. That's the membership. So you have the Board of Trustees, you have the management, and you have the pastorate, and you have the General Assembly. That's my suggestion. Now, what are the corporate governance instruments? You have your constitution, you have your governance manual, you have your annual report, you have your budget and audited accounts, you have your risk management policies. I'm going to explain why these are very important. Many churches, the last time they reviewed the constitution, in fact, after incorporation, they just dumped the constitution. And over the years, the churches have grown and they've extended their operations. Some of them have built schools, some have gone on to establish universities, some have bookshops. But if you go back to your constitution, you find out that those organizations were not contemplated at the time you submitted your initial constitution. Now you will be in breach of the constitution if you go ahead to do those things without explaining or without reviewing your constitution, and putting that, okay, this is the structure that we now, we are now adopting. It's not wrong if you have all these layers of organizations, but it will be wrong if you are expending the money for the organization. When I say organization, I'm talking about the church, without the provision of that being made in the constitution. Okay. Then again, the governance manual, it should be handy and should be very easy for everybody to see. The layer of governance in your organization should be very clear. They should know who is responsible for this. The duties of the board should be clearly spelled out. If you have a council, the duties of the council should be clearly spelled out. If you have your management, the duties of the management should be very clearly spelled out. Then your membership, I'm going to talk a little bit about that also in the course of this presentation. Your membership should be clear. What's the definition of membership in your church? Who are your members? Will you say a congregant is a member? What are the qualifications for membership? Because it has its own legal implication. So membership should be defined in your manual. Annual reports, every church, every organization registered with the Corporate Affairs Commission should submit annual reports. Now, here, churches usually don't do this. Again, it's a breach, of the provisions of CAMA. So if you've not been doing this, I will advise that you have to do, and the point is that you can't start, from where you are. You have to go back, to 1 year after incorporation and regularize the position. Then churches will have budgets and you audit your accounts every year. Then risk management policy, I'm going to talk about this. Those are corporate governance instruments. Every church should have these policies. They are very, very important. The life of the organization depends on it. Your finance policy should be clearly spelled out. How do you enter into a contract? What is the procedure for farming out jobs? You have to have child protection policy in your church. And it has to be clear to both the congregants and the teachers of the junior church. If you follow the news recently, there's a church in Ondo State that had a child missing. And the man was taken to court, as the senior pastor was taken to court, and the court sentenced him to life imprisonment. But if you have a child protection policy, it helps. In fact, the courts want to see, the procedure for child protection. They want to see the things you put in place, the checks you put in place to protect these children. But when those are not there, you will be liable. Then you have to have health, safety, and environment, policy. You've seen churches. I mean, not so many years ago, a church had a guest house, collapsed, and we got to know that there was no building plan approval for that guest house. But if you have policies like this, before you go ahead to build, it will have been stated in the policy, the checks that you have to have in the process, and that will help you, and avert situations like that. Succession planning, 98% of cases in courts that has to do with churches is on this issue, succession planning. Churches have no succession planning policy. Of course, one thing we know is that we are not here to live forever. So when God calls the senior pastor home, so many times the church, is in disarray, and the battle for succession, kicks in, and sometimes it can be very bitter. So there should be a succession planning, there should be social media policy and all of that. So I talked about constitution. Let me skip that. There's the mandatory provision of the constitution. You can't register your association without complying with those mandatory content of the constitution. But there are some additional contents that you need to put in your constitution. And those are the ones I'm going to talk about. You need a preamble in your constitution that talks about the purpose and vision of your organization. Like I said, you need a definition of and criteria for membership. Your membership needs to be clearly spelled out and defined. The objectives and manner and the platform for accomplishing the purpose or the vision of the church should be also clearly spelled out. As you begin to expand, just begin to, revise your constitution so you can put in all those layers and all those platforms there. Then your statement of belief of corporate governance should also be there. What are the don'ts for trustees? The trustees are not to be paid for their work, save for reimbursement of reasonable out-of-pocket expenses. This is one of the controversial areas of Part C, now Part F of the Companies Allied and Matters Act 2020. Trustees are not supposed to be paid, salaries, except reasonable out-of-pocket expenses. Okay, but again, that law provides that if you are an employee of the organization, you can be paid, you can be remunerated for your services in that organization. I'm going to go get there in a while. Trustees are not supposed to earn, but what happens if you're a trustee and you're also a staff of the organization? Because the law allows you to earn salary as a staff, but doesn't allow you to earn as a trustee. Again, and the law has not said you cannot be, as a senior pastor, you cannot combine both roles. Although for corporate governance purposes, you may not be able to combine both roles, but the law has not said that. So trustees cannot simultaneously be employees of the association, or the community. That is to say, if you're a trustee, you cannot be an employee at the same time. So those are the don'ts for trustees. Trustees are not to benefit personally from the association. This is one of the fiduciary duties of the trustees. You should not derive any benefit at all, from running the association. You should not be paid dividend. You should not be paid bonus. Probably sitting allowance by my flight. But apart from that, you're not supposed to benefit from it. You're not supposed even to take, contracts from the organization, except you work in a professional capacity, and you are paid as a professional, for the service you rendered to the association. Then the trustees have these general duties towards the trust property. The trust properties must be maintained, they should be kept. The trust income should be used for the purpose for which it's set out for. You have a duty to submit your returns. You have the duty to keep accounts and to have the accounts audited. You have the duty to comply with the law, and you have the duty to prepare annual reports. The trustees have those general duties. And the trustees have what we call the fiduciary duties. Fiduciary duties means that you are in a position of what we call obedima fide. You are in a position of utmost good faith. And what the law expects of you, number one, you should have duty of care. That is to say, that you should use your skill, your experience, to make sure that the aims and objectives of the associations, they are achieved. You should conduct those duties in good faith. You should not be biased, and you should use, reasonable care and skill in conducting your affairs. Then there should be no conflict of interest in your operation. That is duty of loyalty. You should not subsume the interest of the organization, under yours. You should place the interest of the organization above, yours at all times. So if there are areas of conflict of interest, for example, if you are discussing at a board meeting to give a contract to an organization, and you have an interest in that organization, of course, you should not declare, oh, this organization is mine, and I have an interest in this organization. So either you excuse yourself, when they are talking, because again, you are going to be biased. Naturally, you are going to be biased towards the organization. So, and that will create a conflict of interest. So you should not be involved in conflict of interest. Okay, so the trust property, I said that again should be just used solely for the objectives of that decision. And okay. Now, powers to direct transfer, these are new provisions under section 842 of the CAMA 2020. Now, what CAMA 2020 provides under 842 is that if your account goes dormant, or any of your accounts, the bank will notify the commission, that's CAC. And the commission will request the association to provide evidence of its activities. You remember that you went to CAC to say, I need this money to execute this object, and you are approved to do that. So the thinking of the law is that the moment you have no more objects to expend on, then you should retire that money, because you need to continue to expend that money. You don't warehouse that money. So once the money is dormant, The bank will report to the commission. The commission will say, oh, show us what you've been doing, and let's see. If you have projects in place, oh, I'm saving for, and probably you have 500 million in your account, and you are saving for a project of about 1 billion, and you want to wait till it's about 800 million. So you explain yourself, okay, and they understand that. So where the association fails to respond within 15 days of such request, it says the commission may dissolve the association. Sounds harsh, but that is the law. And now, that tells me that there's another danger there for churches, because churches have moved severally. And I said earlier that we don't update our records with Corporate Affairs Commission. So in a situation where your registered address is at number 4, Ajande Koko Street, and you've moved to number 50, Owode Street, and they contacted you at Ajande Koko Street, and they didn't get you, how will you be able, to answer to any query from the commission? Because the commission will not have your contact address, and you just have 15 days to respond, and they have the power to dissolve that association if you don't respond in 15 days. So that is another reason why churches need to continue to update your account. As you move, you continue to update your records with the Corporate Affairs Commission. So now the bank now will be giving direction. If you don't show up, the CSC will give the bank, direction to move that money into another account of a association with similar objects. Like I said, this is new, it's not been tested, but this power can only be exercised with the approval of the minister. So the Corporate Affairs Commission does not have a final say here. The minister, that is the supervising minister of the Corporate Affairs Commission, has to be involved. Trustees are liable. The liabilities of trustees includes restitution. If money is found to be misappropriated, the court may say they should return the money. The court could fine them and they could be imprisoned. So it's as serious as that. Let me mention this, suspension of trustees. Again, this is a new provision under CAMA 2020, section 8311 provides that trustees can be suspended and an interim manager appointed. It says in a situation where there has been a misconduct or mismanagement in the administration of an association, and where the commission seems expedient, to intervene to protect the property of the association, then can step in public interest. We should remember that incorporated trustee is a public entity. So in the interest of public, it can step in and suspend the managers, who in this case are the trustees. So they can be suspended. And when they are suspended, what happens is an interim management will be appointed, or interim managers will be appointed. But the good news is, from our understanding of this section, is that this suspension cannot take place without a court order. So the Corporate Affairs Commission has to take, the church or the Christian faith of organization to court first together, and then they have to prove, and the burden of proof will be, it's not going to be easy in some situation. Okay, again, section 2 of subsection 2 of section 839 provides that trustees shall be suspended by an order of court upon the petition of the commission or members consisting of 1/5 of the association, and the petitioners shall present all reasonable evidence of such evidence as requested by the courts in respect of the petition. That is, 1/5 of the members of the association can file a petition to court that the trustees be suspended. Now, I talked about membership earlier on. You need to be able to qualify your membership? Is it the congregant or their special qualification for membership? Because of this provision, one thing, and you again, it's good for you to have a membership register. So I've talked about the petition for dissolution now. Okay, let me see. Now, grant for dissolution, where the aims and objectives of the association have been fully realized. For example, if your association, your Christian faith association, is to raise money for people who are victims of, let's say, let me use it, of war or something, and the war is long over, and 10 years after the war, no victims anymore, then you should, the objectives of that association have been realized, and you can call for a dissolution of the organization because the aims and objectives have been realized. Again, some association just exists for a specific period, and after the period is over, they continue to exist. So you might file for dissolution of that organization. Apart from that, the body can be dissolved if it begins to engage in illegal matters, that is, matters that are contrary to public policy. And we've had situations where some associations have been, how will I put it, dissolved, by the government. They will be proscribed and subsequently dissolved. So in case where an association is dissolved, what remains after all the debts and liabilities have been cleared, we go to an association with similar objectives. Okay, I just want to quickly show this. This is Eastern Church, Australia. And you see here, they have their corporate governance statement there. And it says, while Eastern Church is one church, there may be many legal entities that operate the various programs offered. The individual entities have been established for various reasons, which include legislative requirements. Includes legislative requirement, tax status distinction, and resource allocation. Each of these entities have their own unique purpose and requirements. These requirements include such things as who they are accountable to, and how they are governed. For them, they have their corporate governance statements, and that statement explains that they are one church, but they have different expressions. And they said for purposes of taxation, for purposes of organization management, they've registered them as different entities, but they're under one church. So it's very clear for anybody. So if you have a school, if you have an hospital that are affiliated, they can easily be linked together, and you will not be running foul of the law, if you expend on things like that, because again, they've been made parts, of your organization. So I think I stop there.
Thank you so much. This Kama law has been so controversial, and the way you're explaining it now is making it look so easy for me. I'm looking at it that, in summary, I just see that if a lot of churches can adopt it, it's almost like, making it, something that would breed a lot of transparency as far as I am concerned. I don't know why it was raising a lot of dust, with, the churches, why they were apprehensive, maybe they didn't have you to explain it this way.
No, there are a lot of sentiments, and a lot of mistrust in the policy. It's always this and this and this. But again, let me just add, it's not question and answer, but let me just add that the funds, they are public funds. And the Corporate Affairs Commission holds the trustees, as custodians of the funds. So if the funds are mismanaged, that is, you breach the trust, you are no more a faithful steward, then they will remove you and put, other stewards who will be able to comply. And it helps the organization, it saves the organization. Like I said, the organization has perpetual succession. I know of organizations that earn endowments, over 100 years. They've been getting endowments from people who are dead. Because
Absolutely.
People, yeah, okay.
We're going to hold that thought because we have a lot of questions. I'm sure when we go to the question and answer section, we'll be able to raise those questions. But thank you so much for enlightening us on the topic, trustees, qualification and appointments and tenure. Thank you so much. Our next panelist is Taiwo Oyedele. He is the fiscal policy partner and West African tax leader at PwC. He is the thematic leader for the Public Finance and Taxation Policy Commission of the Nigerian Economic Summit Group, NESG. He is the author of Insights on Taxation and Fiscal Policy, Top 50 Issues in Nigeria, the Nigerian Transfer Pricing chapter of the IBFD publications, and a contributor to the annual Doing Business report of the World Bank. He is a prominent speaker at conferences and a regular guest on various business and economic programs on TV, radio, and online media. He is a member of the Ministerial Committee that developed the 2017 National Tax Policy and the 2019 Finance Act. Taiwo is the chairman of the Taxation and Fiscal Policy Faculty Board of ICANN and a member of the ACCA Global Governing Council. He is an alumnus of the London School of Economics, Yale University, and Harvard Kennedy School. He is the founder and president of Impact Africa Foundation and a guest lecturer at the Lagos Business School. He will be speaking on senior pastors' remuneration, decision and taxation implications. I think that's the topic he's speaking on. Thank you so much for joining us this afternoon.
Thank you. I couldn't unmute myself before, so the host didn't allow me to do that.
Yeah, we're trying to get used to technology.
No problem. That's okay. I understand. Thank you very much. Can you please confirm that you're able to see my slides?
Yes, we can see your slide.
All right. Thank you. All right. So thank you to CFA for inviting me. I do think that these are very important issues and topics that we should be talking about now. Maybe issues we should have been discussing years back, but they say better late than never. So what I'm going to be looking at and just building on the presentation by Mr. Adebayo is to say, in terms of remuneration, what should be the main decisions and what will be the tax implications. The content I have in the very brief time that I have is to first look at taxation and society, and then look at church governance and taxation, and then narrow down to ministers' remuneration and tax implications. I will then share my final thoughts and what I consider should be the practical next steps. So in terms of taxation and society, I can say that the tax system is like a tripod that it's composed of the fiscal policy, the tax legislation, and tax administration, and resting on a foundation of both the judiciary for justice and also tax governance. So when we say fiscal policy, what it means is this is how a nation would signify the direction in which they want to go. We want to protect, for example, we want to protect the poor and the vulnerable. We want equality of treatment, or we want people to pay more if they earn so much more. Or we just want people to just enjoy their lives, and we don't care so much about whether they are paying a lot of taxes. So sometimes it's also to promote SMEs, it could be to promote indigenous organizations, it could be to attract foreign investment, and it's not one or the other, it could be a combination, but really, fiscal policy is the tone you set for the tax system. Then the tax legislation is how you translate those intentions you have into law, because you need to provide the legal backing and framework for you to be able to do that which you set out to do. You cannot just go on the street and ask people to pay tax just because you've said you wish you could collect revenue. You must enact it into law, otherwise it will be impossible for you to collect the tax. The tax administration is now how you actually administer those policies and those tax laws. In Nigeria, because Nigeria is a federation, you have the tax authorities at the center, and that's mostly the Federal Inland Revenue Service and the Nigerian Customs Service. But of course, you have so many agencies of government who are also generating revenue, even though my personal view is that when we ask government agencies, or more broadly, state-owned enterprises to start raising revenue, they're likely to lose sight of the fact that they're there to render services and therefore complicate the ease of doing business by trying to extract as much as possible from the people instead of facilitating them. The whole idea of taxation is in fact a social contract, and the more successful people are and businesses, the more the ability of government to be able to collect tax. So that is fundamental. I think that the challenges we're facing in Nigeria today, including the ongoing protests around NSAS, has its root cause, in my view, also in tax. And what do I mean by that? So today, the pastime comments in Nigeria is lawmakers are earning too much, the politicians take all the money. And to some extent, I do agree with those sentiments, because if you live in a very poor society, it's immoral to hold political office and then pay yourself so much. But the reality is that if today, all political office holders, local government, state, and federal level, including the National Assembly, if they decide that they will collect 0 or 1 naira only in a year as their revenue, and we manage to eliminate corruption 100%, and we also remove wastage from our system, Nigeria will still be poor. That's because Nigerians are poor, so they cannot pay taxes. So our entire tax revenue in Nigeria today, combined, federal, local government, all 774 of them, state, all 36 of them, plus the FCT, all the revenues we generate in Nigeria put together is less than what South Africa makes from personal income tax alone. This is after exempting people who earn about 2 million naira equivalent per annum from tax. So in South Africa, if your salary or your income in a year is about 2 million or less, you pay 0% personal income tax. Yet they make more money from personal income tax than us. If Nigeria were to be where it's supposed to be in terms of generating revenue, then the conversation about how much to pay police would be very easy to handle, because we then use the money we have to pay the people who need those amounts and they are deserving, teachers, policemen, and so on and so forth. So having said that, this tax system relies on the judiciary to serve as a form of balance, because otherwise, if you have absolute